Hi, and thank you for joining me here on YouTube. My name is Will Hannosh. I'm an attorney here in San Diego, California. I'm in the Mission Valley area. I practice in the areas of family law and elder abuse for the victims. Within the family law context, I do divorce, legal separations, annulments, custody visitation cases, child support, spousal support. I also do adoptions, and I also do restraining orders. I've done many restraining orders in my 16-year career. The topic for today is the domestic violence restraining order and its impact through a statute called Family Code 3044, which is very important. Family Code Section 3044 says simply this: if a court has found that you've committed or perpetrated an act of domestic violence within the last 5 years, then the court will hold or carry a presumption against you as the restrained party. What that means is if a permanent restraining order has been issued against you within the domestic violence context, then the court is actually restricted from giving you additional parenting time or custody and visitation as a result of Family Code Section 3044. And that's why it's a really important statute to talk about. If you are faced with a restraining order, you're the restrained party, you're the respondent, and you're also trying to gain some parenting time, some custody of your child or children. I think it's a topic that's not really discussed as fully or with as much detail as it should be, and that's why I'm doing this video today. What I noticed is people will go to their domestic violence restraining order hearing or trial. The permanent restraining order is issued against them. Perhaps the hearing or trial did not go so well for them. And then sometimes, I'll get a call from a restrained party. They want to meet with me. They've been placed on supervised visitation, and now they want to meet with me. And a lot of my clients, or a lot of people who consult with me, will tell me that Family Code Section 3044 wasn't really explained to them before they went to the hearing, which is concerning. So here's that explanation. Let's take a hypothetical. This is a standard hypothetical. It's happened to many people who've had to go to family court to answer a restraining order. You're served with a temporary restraining order. The sheriff or the courier served you. It's a temporary domestic violence restraining order. You're given a notice date, so you're notified that you have a hearing date and time. So once you're served, you need to be there. If you're not there, no matter what the allegations are, no matter how you view the allegations, whether you think they're true or false, then you still need to be at that hearing if you have been personally served, if you've been given legal notice. So you got to go to that hearing. You have a right to one continuance under the law if it is a domestic violence restraining order. You're given a hearing date and time, you go, but you decide for whatever reason, you decide you don't want to use your statutory right to a continuance at that hearing. So let's say you want to go forward that day for whatever reason. Hearing is held and the court issues a permanent restraining order against you. That restraining order, we call it permanent, even though it could be issued for 1 year or 3 years or 5 years. It all depends on what the petitioner asks for and what the judge ultimately orders in the ruling. If a permanent restraining order has been issued, then the court must follow Family Code Section 3044, and it has to hold a presumption that it is not in the child's best interest to have increased parenting time, increased custody, visitation, or parenting time with you, the restrained party. And that's because the court, by virtue of the restraining order being issued, the court has found that there has been an act of domestic violence committed or perpetrated by you within the last 5 years. Now, question may arise. Can a court find that there's been an act of domestic violence perpetrated by the restrained party, even if a restraining order was never asked for, even if nobody ever petitioned for a restraining order? The answer to that is yes. A court can find that an act of domestic violence was perpetrated, even if it has no record of a restraining order. Does it happen? Yes. Does it happen often? Not often, but it does happen. What I want to focus though on is that if you want to make no mistake about it, that if you had a permanent restraining order issued, then Family Code Section 3044 becomes the giant that you need to slay. In other words, Family Code 3044 is a presumption the courts hold, but it is a rebuttable presumption. What does rebuttable mean? It means that you can overcome that presumption. There are ways to fight that presumption, to overcome it, to slay that giant, so to speak. Because it is a giant if you're trying to get increased time with your child or children. How do you overcome, or how do you rebut Family Code 3044 after a permanent restraining order has been issued? Here are some ways. I found that courts will always order a restrained party to take a batter's counseling program that may last 26 to 52 weeks. That's just part of having a permanent restraining order issued. So you would need to take and complete a batter's program for domestic violence. You should take a co-parenting course. That's something that is going to benefit the child and you. If this is an issue, if this is applicable to your case, you should take a substance abuse class. If you're struggling with either alcohol or drugs or both, then substance abuse class is the type of thing that you'd want to take and complete and show proof of to the court. You'd want to show proof of the co-parenting course, of course, and you'd also want to show proof of the batter's program as well. If anger is an issue, if anger is a weakness or something that you struggle with, now although it is something that's encompassed or covered within the batter's program, anger is, there's nothing wrong with taking an additional anger management course or seeing a counselor for anger management. That's always a good thing. And you'll obviously get a separate certificate of completion for taking that course, even though it's already encompassed within batter's program. If you need individualized therapy for whatever issue, emotional, mental health, psychological issue, then an individualized therapy is always recommended based on the need, of course, based on your case. And you'd want to show the court proof of that. The other thing I would want to say, and this is very important, is your communication with the other parent should be more civil. You do need to take strides. I understand that you have a history. I understand that you've had a rocky relationship with the other parent. But you do need to take strides in order to communicate better, in order to give and take in a more civil and more peaceable manner with that other parent. That needs to show in all of your communications. If you're emailing the other parent, that needs to show in the emails. If you guys are using a co-parenting communication app like Talking Parents or Our Family Wizard, that demeanor of peaceableness needs to come through because the court's going to see it. The other thing I would add is if you were on supervised visits, regardless of whether the monitor is a professional, a paid professional or not, but if you're on supervised visits, this point may sound obvious, but I'm going to say it anyway. You need to conduct yourself in a peaceable and civil manner at all times. That just needs to happen. You don't want to create strife. You don't want to, create any unnecessary confrontation. The communication should be simple, as polite as possible, civil, and it's not a place where you want to jump to conclusions or create, angst or strife if you can avoid it. You want to have the most exemplary conduct during supervised visitation. And why is that so? Because if you have a professional monitor, or if there's a monitor who's going to issue a report to the court, that's all going to show in the report. So you want that report to be exemplary. You want that court to see that you are a parent who's on their best behavior. That does need to happen. Family Code Section 3044 is taken very seriously by courts all across California, as it should be. And you want to also show the courts that you understand the statute, that you are bettering yourself as a parent, as a co-parent, and as an individual. It's all going to be for the benefit of the child. And so what I mentioned, of course, are as far as overcoming Family Code 3044, those are just examples of what you can do to show the court that you've rebutted that presumption. And once you complete those courses, once you do what you need to do, it will involve a batter's program, that's for sure, but it may also involve or include the other things I mentioned. You want to go back to court and show that you understand the statute and you've taken all steps necessary in order to overcome it. As a practitioner for myself, I don't wait until the hearing or trial to discuss the impact of Family Code Section 3044. I discuss it with my client as soon as they come in for a consult, or as soon as they're served with a temporary restraining order. I think that's the time to talk about it, not down the road, not on the day of trial or the night before trial. If you want to contact me, then go ahead and call me, or you can email me. My phone number is down below. It's I'll just say it anyway. It's 619-244-9835. You can also email me there. My contact information is just right down on the screen. I'm in the heart of Mission Valley, so I'd love to meet with you if you have any. If you have a legal matter where you need the advice of a serious and seasoned and experienced practitioner, I'd love for you to contact me so we can discuss your case. Thank you for seeing me here on YouTube, and have a great day. It was great talking to you. Bye.